Hi friends, how are you everyone? So friends, today in my series I will be concentrating on the sample papers which I've earlier also did. So this series will be held for the sample papers which is continuing for 2011 6th March, and this is for contract law including specific relief, special contracts and negotiable instrument, friends. So this is category A, friends, and the question number 22 says an agreement is not voidable if the consent is caused by, the answer is undue influence, friends. An agreement in restraint of trade not accompanied by a sale of goodwill is voidable at the option of either parties. Friends, this I have also done in my CA classes foundation, and there it was a mercantile law which says the contract act also, and it's a very interesting act which is there even in your graduation, even in your CA, and it's very important for a person to know about contract, because even if you are not part of law, this is important for a business, for a proprietor, even for a company, because the contracts will be always there. An agreement should be known. A legal contract, how it comes into picture, a person should know about it. So now the question number 24 says when one party resigns a voidable contract, it must return any benefits received under the rescinded contract to other party, friends. Okay, question number 25, friends. Which of the following statements is least accurate about partnership law in India? So the answer is liabilities of the firm cannot be enforced against the partner of the firm personally. So that is important, friends. So you done understand? So now we are going through category B. Question number 26. A sends a letter to B offering to sell 200 grams of gold at a certain price. So he sends a letter to B offering to sell 200 grams of gold at certain price and requests B to convey his acceptance by post only. B writes a letter accepting A's offer and hands it over to his PN and asks him to mail it for him. The PN forgets to do so and posts the letter after 2 days. A, day after the letter is posted, calls B to ask him whether he has replied to his offer, and B informs him that he has accepted the offer by post. A receives the letter a couple of days later but opens it only after a week. When was the acceptance of B complete against A? So now the principle behind its, friends, I will be letting you know. It says that an acceptance of an offer must be communicated to the other person in order for it to be valid. In case of communication by a non-instantaneous mode of communication such as post or email, or acceptance is complete as against the offer, or when the acceptor puts it on a mode of transmission outside the control of the acceptor. The answer to this question is the acceptance was complete as against A when the letter was posted. Okay, so the day the letter was posted, the acceptance was there. That's important, friends. So now question number 27. It's very important to know that day was important when it was posted. So that was the time when B has accepted his offer. So that was the day the offer has been in the mind of B, being accepted by him. So that's the day, right, friends? 27 question. A gave some goods to B, okay, and asked B to store them in a warehouse for a period of time and clean them regularly, okay. A agrees to pay B a fee for the use of warehouse and a fee for cleaning, and B agrees not to retain the goods under any circumstances. Once the contract expires, upon the expiry of the contract, A demands that B hand over his goods. Can B retain A's good until A pays him the agreed fees? Principle, friends. If the bailee, in accordance with the purpose of the bailment, renders any service involving the exercise of skill or labor in respect of bail goods, the bailee has, in absence of a contract to the contrary, a right to retain the bail goods until the bailee receives due remuneration for the services rendered in respect of the goods. The answer is B cannot retain the goods as he expressly agreed not to do so in a contract, even if he is not paid either of the fees. So B cannot. Okay. So Here we can say that how these contracts act as a promise, and it helps the honesty and the discipline to be maintained in kind of a two-way process when there are two people involved in it. It's important actually. Question 28, friends. On December 5th, 2010, company A enters into a contract with company B to supply company B with 1,000 shirts especially designed for sale on Republic Day. No time for delivery is mentioned in the contract, and it is not stated whether time is the essence of the contract. Company A delivers the shirts after the Republic Day celebration in 2011 are over. Has the contract been validly performed? I will again repeat the question in Hindi. दिसंबर 5, 2010 को कंपनी ए एक कॉन्ट्रैक्ट में एंटर करती है कंपनी बी के साथ, जिसमें बी को 1,000 शर्ट्स डिज़ाइन करनी है रिपब्लिक डे के लिए. कोई टाइम मेंशन नहीं है कॉन्ट्रैक्ट में, एंड कोई भी एसेंस ही नहीं है टाइम का. कंपनी ए डिलीवर करती है शर्ट आफ्टर रिपब्लिक डे सेलिब्रेशन, मतलब कंपनी बी को देना है उसको, ए को. जब रिपब्लिक डे खत्म हो जाता है तब वो देती है. हैज़ द कॉन्ट्रैक्ट बीन वैलिडली परफॉर्म्ड? प्रिंसिपल टाइम इज प्रिज्यूम्ड टू बी एसेंस ऑफ द. In case of a commercial contract, parties may indicate clearly whether or not time is the essence in the contract, and this intention will determine whether time is of the essence. If no time for performance is specified, a contract must be performed within a reasonable time. The answer, reasonable time. So the answer is the contract was not validly performed, as time was clearly essence of this commercial contract, and it is reasonable to expect company BA to have delivered the shirts before Republic Day celebration in 2011. So friends, again, something which I have heard, that prudence and common sense is implied. Something which is implied, you cannot ask the law to state that. So the common sense and prudence is something which is implied, that this has to happen. So if you say that that is not taken care, that's not an excuse. It's not written there. It's not an excuse. So that kind of common sense. So now friends, subject 5, criminal law. 1, the Indian Penal Code. That's the subject, and we are going through the 2011 questions. Category A. If a person is intoxicated against his will and commits a crime when he is incapable of knowing the nature of his action, then he will be punishable, because being intoxicated is also an offense. Again, the same way, not knowing law is not an excuse. So being intoxicated doesn't mean that you can murder anyone. So that's important. Question 30, Section 53 of Indian Penal Code 1860 provides 5 forms of punishment, namely death, imprisonment for life, imprisonment either rigorous or simple, forfeiture of property, and fine. Imprisonment for life under Section 53 means rigorous imprisonment for life. Okay, so this is important. It's very easy to understand. Then you have question 31. In which of the following cases does culpable homicide amounts to murder? The answer is, I will let you know the cases. If a person committing the act that caused death knows that it is so immensely dangerous that it must in all probability cause death or such bodily injury as is likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such inquiry. Second is, if the act that caused death is done with the intention of causing death, intention ही है. If the act that caused death is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of a person to whom the harm is caused. Again, there is the intention there. If the act that caused death is done with the intention of causing bodily injury to any person, and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature of the cause of death. So intention is always there. So if that is there, then it amounts to murder. Of course. Culpable homicide, that is. Okay, question 32. Certain acts that lie within exceptions, such as that the defendant was of unsound mind when committing the act charged as an offence, are not treated as offence. Who has the onus of proving that an act lies within an exception? So answer is, the defense must prove that the accused is of unsound mind. Right, friends? Category B. A. A man asked B, an adult woman, if he could have sexual intercourse with her. B refused. brandishes a gun and threatens to kill her neighbors if she does not consent. B gives consent out of fear for the lives of her neighbor and they have sexual intercourse. A is charged with rape. In the court, the defense argues that at the time of sexual intercourse, B had given her consent. Which of the following statement is the most accurate application of principle below? Answer. Okay, so I will repeat it in Hindi. ए ने एक आदमी है, उसने बी एक वुमेन से कहा क्या हम सेक्सुअल इंटरकोर्स करें. बी ने रिफ्यूज़ करा. ए ने गन रखी एंड थ्रेटन्स की वो उसके पड़ोसियों को मार देगा अगर उसने हाँ नहीं करी. तो उसने अपनी आउट ऑफ फेयर हाँ कर दी कि वो उसके पड़ोसियों की जान बच जाए. एक तरह से रेप हुआ. कोर्ट में डिफेंस आर्ग्यू करता है कि टाइम ऑफ सेक्सुअल बी हैड गिवन हर कंसेंट. क्या ये एक्यूरेट एप्लीकेशन है प्रिंसिपल का? क्या उसने सच्ची में कंसेंट दिया था? प्रिंसिपल कहता है ए man is set to commit rape when he has sexual intercourse with a woman under circumstances such that the sexual intercourse is against her will, is without her consent, or with her consent when her consent has been obtained by putting her or any person in whom she is interested in fear of death or hurt. So, of course, it is a rape as sexual intercourse was against her will and the consent was by threat of killing her neighbor. So, this is coercion. A police officer is directed by her superior to arrest B. Okay. A arrests B's younger sister. C is in mistaken belief that she is actually B. Has A committed an offence? Answer is A has not committed an offence since she has made a mistake of fact in good faith and not a mistake of law in arresting C instead of B. It is a good faith. मतलब जानबूझ के नहीं किया. 35 question. A asks B to forge a registered sale deed for him and B does so. A misrepresents the forged sale deed to be genuine one and sells C's property to D. Which of the following statement is most accurate of the principle below? So the principle says whoever fraudulently or dishonestly uses as genuine any document which he knows or has reasons to believe to be forged document shall be punished in the same manner as if he has forged such document. Answer. B is guilty of forgery. A is guilty of using the forged document as genuine. A shall also be punished as though he had not forged the sale deed, friends. That's important. Subject C, criminal procedure. Question 36. Taking cognizance of an offence under the Code of Criminal Procedure 1973 means taking judicial notice of an offence. Which of the following courts may award a sentence of imprisonment for life? A court of session. If an offence is classified as a non-bailable offence, it implies that a bail may be granted only through exercise of judicial discretion. That's important. The Code of Criminal Procedure 1973 deals with procedural aspects of criminal law. An exception in the Code of Criminal Procedure 1973 where the proceedings are civil in nature is a proceeding pertaining to maintenance. Category B. During a trial for murder, the prosecutor elects that the murder weapon is hidden in the house of accused but his wife is not allowing him into the house. What should the prosecution seeks from the court to secure murder weapon? The answer A. Searches warrant to inspect the accused's house for murder weapon. So friends, now I will be leaving you here and we will be coming back with the same questions because I want our YouTube channels to be short and crisp so that you can learn easily and revise wherever you are. Till then, take care friends. Bye. Please be safe. Spread love. Love yourself too. Take care. Bye.